Okay, we are going to get started. So, welcome everybody to the motivation info session. It's great to see this turnout. We were the first surprised to see how this event got bigger and bigger along the weeks. This speaks loud and clear about the time that we are living and the uncertainties that we, the international scientific community, face here in the US. I have to say a few words about the importance that our collective represents. Research in the United States is made and advanced by many international PhD students, postdocs, and associate researchers who came here with visas and then opt to become permanent residents. Research in the United States is made, according to the NSF, by 5.2 million of international researchers. This represents 20% of the sector, coming from just 8% 12 years ago. So this is something that is becoming more and more bigger and bigger. So this event is aimed at providing this large community with information for the transition into permanent residence to remain and make their best science in the United States. I want to finish by thanking everybody involved in the preparation of this event. This would have not been possible without all the partners that helped to put this together and the sponsors that provide the resources to make this happen. I will mention the organizers, mainly the Columbia University Postdoctoral Society, INET New York City, the Postdoctoral Executive Committee at Mount Sinai, ECUSA, the Spanish Scientists Association, and the Einstein Postdoctoral Association. And also the sponsors, the Office of Postdoctoral Affairs from Columbia, the Rockefeller University Dean's Office, and the Mount Sinai NYU School of Medicine and Wayne Cornell Offices of Postdoctoral Affairs. So I want to give a few minutes to introduce some of the organizations that have been involved. Michael Scott will speak first on behalf of Columbia University Postdoctoral Society, who first conceived and lead the organization of this event. Linda Mola will represent INET New York City with their involvement. We will not be having this conversation today. And finally, Julian will speak on behalf of ECUSA, the Spanish Scientists Association, who helped in the organization and facilitated the live streaming of this event, so those who couldn't get tickets on time or are far from here will be able to get information and join the conversation. We will be live streaming the event through YouTube, and you can tweet any questions you might have using the hashtag #ImmigrationInfoCU. So without further ado, Ms. Michael, come and provide introduction to the Postdoctoral Society. Private registration table. Okay, we'll start with Linda.
Hi, good evening, everyone. So my name is Linda. I'm here to represent INET NYC. It stands for International Networking in New York City. So we are an organization that started back in 2014. We are volunteer-based. We have two very important missions. The first one is to support professional development of international scientists that are training in STEM in the New York City area, so different institutions. And while doing this, we hope that we can also provide a way to build the community and also facilitate the interactions and networking between international scientists between different institutions. So we do have in our board many representatives from all of these different institutes and research organizations. Currently, we don't have representation from the institutions here in the red box, and if someone here in the audience is interested in getting more involved and they are passionate about our mission, please get in touch with us. Also, if you are from an institute that you don't see here, please get in touch with us if you are interested. So if you are curious to know about what we have done in the past and you are interested in checking out things that we will do in the future, please check out our website, inetnyc.com. And we are also very active in social media, in Twitter, LinkedIn, Facebook, you can also check that out. So please, if you are interested, check our website. You can sign up as a become a member, and also during the networking, you can come say hi to some of us who are here today. So like the people that are from INET who are here already to just stand up so people can see them. So we have Hyman here, Anna, she's probably coming late, and Helena is also here, and myself, and also Nina is coming later. She's here at home. Okay, I hope that this event will be useful for many of you, and it's going to benefit you in the future. Thanks.
Thank you, Linda. And now we have Michael Stokes, the co-president of the University Postdoctoral Society.
So, thanks a lot, Carlos, and welcome everyone. As co-president of CUPS, it's my pleasure to welcome you to Columbia today. Now that I have your attention, I'd like to take a quick minute to tell you a bit about what we are and what we do here. Basically, our unofficial motto is we're an organization by postdocs for postdocs. What we like to do is put on a number of social and professional development events, such as tonight, to promote postdocs at Columbia and within New York City. When you join CUPS, generally you participate in one of three subcommittees. Advocacy basically acts as a liaison between the administration and the postdoc body of the university. The Research and Professional Development Committee puts on workshops aimed at enhancing the career prospects and skill sets of postdocs at Columbia. And the Social Committee puts on networking events and different types of programs to help create a greater sense of community at Columbia. If this sounds like something that you'd be interested in participating in, and you'd like to come join us in supporting our mission, email us at joincups@columbia.edu, and we'll be happy to hear from you and bring you into our organization. Thanks everyone, and enjoy the program.
Finally, Juliana, representing ECUSA.
Hi, good evening, everybody. So I'm Diana. I'm glad to be here representing ECUSA. We are Spanish scientists in the US. We are a non-profit organization, and since 2014, we are also community-based. Our objectives are to establish a network for scientists in the US, also increase the social awareness of science and technology, and facilitate the interaction between Spanish and American public and private institutions, among others. We are divided in 5 different chapters around the country. Well, this one is the tri-state area chapter, and we are divided in 7 different working groups, such as science outreach, communication, advisory, fundraising, women in science, networking, and professional development. We are doing different activities, workshops, and talks, like information sessions like this one, as you can see in the pictures. If you want to volunteer, such as or collaborate with us, please contact through our channels. And I hope you enjoyed the session. Thank you.
Finally, I'm going to introduce you to the speaker, Aviva Milton. Aviva is an associate attorney at Fragomen in the New York office. She represents individual and corporate clients on all aspects of US immigration, including non-immigrant visas, permanent residence, and citizenship. She provides counsel on all major employment-based temporary and permanent visa categories, as well as family-based permanent residence applications. So, thank you for coming, Aviva.
pleasure to be here on this beautiful day. As was mentioned, I'm an associate attorney at Fragomen Worldwide, which is a global immigration firm in over 40 countries around the world. I've been with the firm since 2014. Before that, I was at boutique firms, and I've been in the field since about 2009. So I've worked with many individuals like yourself over the course of the last 8 years. So I was asked to talk today about transitioning from non-immigrant visas, from one non-immigrant visa category to, say, another non-immigrant visa category, or to an immigrant visa, and sort of, the process involved and what are the options. So that's what we're going to talk about today. First, non-immigrant visas and immigrant visas, and also some of the recent changes in U.S. immigration law and policy. I'm sure you've all seen the news regarding some of the executive orders that have come out recently that have impacted people, including probably in the room. So that's what we'll touch upon at the end. First, just briefly about our firm. As I mentioned, we're a global firm with 40 offices in over 20 countries. Even though we have offices around the world, and we do both U.S. immigration as well as immigration to other countries. We have one organizational and leadership structure. Myself, I do only U.S. inbound immigration, but I also get questions from clients about sort of sending U.S. employees abroad, and then I will just refer them to our global team. And we have about 3,500 professionals worldwide, and about 120 partners, and over 550 attorneys. Okay, so let's get started with non-immigrants. As I'm sure most of you know, non-immigrant is a foreign national who's coming to the U.S. temporarily on a specific visa. In most cases, it's important to maintain a residence abroad while you're here, except that some categories do permit dual intent. So, and that's important for those of you that are interested in permanent residence. In many cases, you're not really supposed to have that intent, but if you're on H-1B or an L-1, you are allowed to have that immigrant intent. Categories of non-immigrant visas, and including professionals. Many of you probably know about the H-1B visa category. There's also separate visa categories for professionals. If you happen to be a national of Canada or Mexico, that would be a TN. If you're Australian, that would be E3. And if you're Chilean and Singaporean, that would be H-1B1. There's also a visa category for nationals of extraordinary ability, which is an O1, which can be very helpful in certain circumstances, which we'll talk about later. And then I'm sure a lot of you know the F1s for students and J1s, and also J1s for trainees and scholars. So let's first talk very briefly about students. It's for nationals entering for academic studies, admitted for duration of status, so essentially until the end of the degree program. Work authorization is possible in the form of optional practical training, which somebody can get either pre-completion or pre-graduation or post-graduation. And there's also sometimes available curricular practical training, which allows somebody to engage in this training sort of off-site if it's part of an established educational program. I was specifically asked to talk about sort of changing status and if and when that's possible. F1 students that want to change status either to another visa category or adjust status to permanent resident are able to do that. However, in many cases, you'll have a travel restriction upon filing a petition for an application. So, and this is sort of aside from the fact that you're not really supposed to have an intent to do that when you first enter on the student visa, but it is possible if you kind of develop that intent, while you're already here. But like I said, there's a travel restriction in many cases, so that's something that you have to be aware of, and also, of course, discuss whomever is, assisting you with an application. So J1 exchange visitors, so that's a category that's open to many different types of visitors, including trainees, interns, professors, research scholars, and foreign medical graduates. It essentially allows the foreign national to participate in a approved exchange program and study or do research in the fields. Similar to the F1, changing status to either another non-immigrant visa category or permanent residence is also possible. However, once again, you may have a travel restriction. So once again, very important to sort of plan around that. And also, one added factor about J1s is that some are subject to a 2-year foreign residence requirement. That could be, for example, because the particular field is on what's called skills list between the US and a different country. Or it could also be because, for example, government funding, so either the J1 program is funded by the US government in some way, shape, or form, or foreign governments. And if you're subject to a 2-year foreign resident requirement, you are not able to change status to certain visa categories, including H1B or L1, or permanent residence, unless either one, you first fulfill the requirements, or you get a waiver on the requirements. We've seen a lot of people that are not really aware of that. So every time we'll see somebody who wasn't a J, we always have to ask for their J1 visa stamp and their DS 2019, which is the certificate of J1 eligibility. If either one or both say that you're subject to the foreign residence requirement, it's very important that this is carefully addressed sort of ahead of time. It is possible to get a waiver in some circumstances of the requirement. There's 5 different bases, including getting a no objection statement from your own country, or request by an interested governmental agency, exceptional hardship to a U.S. citizen or a permanent resident spouse or child. However, it's not always easy, so it's something that should be reviewed, ahead of time, and ideally with a lot of time in advance before you really need to adjust your status. We get a lot of clients that, for example, are here in a J1, are subject to the foreign residence requirement, but then they end up marrying a U.S. citizen, for example. So then they really want to, be able to, stay here permanently and also apply for a green card based on marriage. However, in those cases, somebody who's subject really has to take care of that first before he or she can apply for a green card on that basis of being married to a U.S. citizen. So the next non-immigrant visa category is for specialty professionals. So it's open professionals that work in specialty occupations, which is an occupation that requires at a minimum a bachelor's degree in a specific field. In general, there's a 6-year maximum period of stay. It's not issued all at once. It's generally issued in 3-year increments. Under certain circumstances, you can actually extend that beyond 6 years if that's necessary. Specifically, if an employer has commenced a green card application on your behalf. So there is an annual cap on H1B visa numbers. And so that's 65,000, and there's also 20,000 that are set aside for U.S. master's degree holders. If you happen to be cap subject, it means that the window to file a cap petition is very short. In the last couple of years, it's been the first 5 business days of April. After that, basically, they run out of numbers. I mean, there's too many filings already in that first week. So the government doesn't allow you to file any more petitions. Many of you I know are employed with either universities or nonprofit organizations. Thankfully, these organizations are cap exempt, meaning that this issue of sort of the filing window and also the cap actually doesn't apply. So, and that's a huge distinction. I mean, it's incredible. It's incredible the difference between somebody who's working actually for a cap exempt institution versus somebody who's not, in terms of when he or she needs to apply and sort of the process, and the fact that, for example, this year there was only a 40% chance of getting selected for an H1B visa number if you were subject to this cap. Because essentially there's a lottery, and this year there were 199,000 filings for a total of about 85,000. Once again, changing or adjusting status is also possible. Generally, because the H-1B visa category is a dual intent visa category, there's no travel restriction, except in certain situations. Currently, premium processing is suspended. Premium processing is essentially one option, normally, which is that if you file premium processing, the government will issue a response within 15 calendar days, which in many cases, of course, is very favorable. I mean, employers want to get a quick response, and so do the beneficiaries. However, because it's suspended right now, currently petitions are taking 6 months or more. So it makes it very difficult to plan for both employers and beneficiaries. And especially because of that, now more so than under normal circumstances, do some H-1B, beneficiaries have a travel restriction. So now let's talk a little bit about the O1 visa category, which is, a visa category for aliens of extraordinary ability. It's open for nationals in quite a few different fields, so sciences, education, arts, business, and athletics. There's 3 different standards. In sciences, the standard is that the foreign national must be of a small percentage who has risen to the top of their field, and we generally say 1 to 2%. You also have to be able to demonstrate sustained national or international claim. And how do you do that? You do it by basically showing evidence that you meet at least 3 of the criteria that are listed on the screen. So publications by you, publications about you, membership in associations that, there's more to it than this, but membership in associations that requires outstanding, credentials, critical capacity, that you play a critical capacity for some organization. Original contributions, you've done the work of others, and you've won awards. O1s are actually a good option for those that, for example, can't get an H-1B because, say, they can't get or they don't get a job with a CAP-exempt institution. It's also a good option for nationals that are subject to the J1 foreign residence, 2-year foreign residence requirements. Because as I mentioned, you can't change status to H or L or permanent resident, but you're able to get an O1. So it's something that's definitely a good option to keep in mind if sort of these things that I mentioned sort of apply to you. Not everyone will sort of meet the eligibility requirement for an O1, but generally, if you're in science, it's a good visa category to keep in mind. So now let's move on to immigrants. Immigrants, are also known as green card holders or permanent residents. And it's the difference, of course, between immigrant and non-immigrant is that it's foreign nationals coming to the U.S. sort of on a permanent basis, as opposed to the temporary non-immigrant basis. The problem or the issue often that comes up is that there's an overall cap on the number of immigrants that they enter the U.S. each year. So in many categories, which we'll talk about later, there's a backlog. It's based in part, so every month the Department of State will release a visa bulletin, and the visa bulletin will tell us sort of for whom is the green card available, who is able to apply for permanent residence. And that's based on the immigration category, so the category that you're applying under, your country of birth, your priority date, which is a date in which either a petition, an immigrant petition is filed, or a labor certification, which we'll talk about later. And also the overall demand, so sort of how quickly, does the government get through these applications? Does the demand sort of increase, or does it sort of slow down? So in many categories, there's actually very lengthy backlogs, including if you, for example, were born in India or China. Unfortunately, the categories we'll talk about in a second, EB2 and EB3, there's years of backlogs. So there's 3 bases primarily to apply for permanent residence. One is family-based. So essentially, if you have a family member, a qualifying family member who's able to sponsor you for permanent residence, that's limited to 480,000 per year. So it's definitely the bulk of the numbers go to the family-based applications. Then there's employment-based. So if you're sponsored by an employer, that's limited to 140,000. So you see quite, the difference quite, it's very large. And then you have the diversity visa lottery. So for those that are lucky enough to, get selected for a diversity visa, might be able to adjust to permanent residence, but it's limited to $50,000 per year. So given that I know most of you are probably, would be sponsored by an employer, we're going to talk a little bit about that process. So it's either a 2 or 3-step process. So the first step is a labor certification that is held in the Department of Labor, where required because it's not required in every category. Then the second step is the immigrant preference petition, also called the I-140 petition, which is filed by an employer based on sort of the offer of employment that's being offered to you. And it's processed by USCIS, which is U.S. Citizenship and Immigration Services. The third step is either adjustment of status or constant processing. Adjustment of status is done when you're already here, for example, on an H-1B or on an F-1 or on a J-1. And then alternatively, if you're actually abroad, which is also possible that you're sponsored for a green card while you're abroad, you would go through consular processing. So with respect to the different employment-based green card categories, so there's 3 principal ones. EB1, which also stands for employment-based first, that's for priority workers. They get the highest preference in the system. Then there's EB2, which is for advanced professionals and aliens with exceptional ability. And then there's EB3, which is for professional, skilled, and unskilled workers. And then there's a few other categories, but those are much less common. So EB1 priority workers, it's limited to 40,000, but it is actually a very good category because in most cases there's no backlog. Actually, right in June, coming up in June, there's for the first time since a long time a backlog in the India and China category, but that's uncommon. And also we expect that to sort of not be, maybe stay that way for a couple of months, but then it'll probably go back to being current. So there's 3 subcategories in the EB1 category. There's EB1A, which is for persons of extraordinary ability, which is similar, sort of similar to the immigrant version of the O1 that I talked about earlier. So once again, it's for people that are working in sciences, arts, education, business, or athletics. The benefit there is that you actually could self-sponsor. The standard is very high, so not everyone's going to qualify and not everyone's going to get a petition approved, but for those that do and that don't want to rely on the employer, this is a good option. Then there's the second one, EB1B or EB12, is for outstanding professors and researchers. In that case, foreign nationals' work must be internationally recognized, and also you have to be sponsored by an employer. And you have to seek entry for a tenure or tenure track teaching position or a research position. And third category is for multinational managers or executives. If you happen to work for an employer who has an affiliate abroad, and before coming to the US, you actually worked for that affiliate abroad in a managerial or executive capacity, you can be sponsored for EB13 or EB1C for multinational managers or executives. So now let's talk about EB2, advanced degree professionals and persons of exceptional ability. So that's also limited to 40,000 per year. Advanced degree professional stands for either a master's degree or higher, or a bachelor's degree plus 5 years of progressive experience. A labor certification is required, so you'll be subject to that 3-step process. But it's a good option because also the backlog, except for India and China, if you were born in one of those countries, the backlog for EB2 is actually generally there's no backlog. Meaning, you don't have to wait between the petition and the adjustment of status application to apply for green cards. So then separately, this is less common, but there's also this application for persons of exceptional ability. Generally, if anyone were to do that, it would be under a national interest waiver. So it allows you to basically waive the labor certification process, so that's the first process. If you can show that your employment will be in the national interest of the United States. For many years, there was one standard for that, which was sort of vague. And in 2016, in December, they came out with a new standard, which is sort of intended or meant to be easier easier to meet, or at least more clear. So, we do expect that sort of it becomes a little bit of a more useful category. So EB3 is for, like I said, professional, skilled, and unskilled workers. Like I said, lots of backlogs. Also, there's a labor certification that's required. So now let's talk about the labor certification. What does that really mean? Well, essentially it means that an employer has to recruit for a U.S. worker in order to be able to offer the job to the foreign national, before you're offer the job to the foreign national. So you have to go through, the employer has to go through the recruitment process, which has very kind of strict advertising and recruitment requirements. Also, the employer must obtain a prevailing wage determination from the Department of Labor before being able to file this labor certification application, which is also called PERM application. So if you ever sort of hear that term, PERM, that's really the same as a labor certification application. So essentially, once it's filed and once the Department of Labor certifies it, it basically means the Department of Labor says, yes, you've done your recruitment and you weren't able to find a qualified, willing, able, and available U.S. worker, and also your employment of this foreign national won't adversely affect the wages and working conditions of U.S. workers. Those are the two main attestations. The challenge with this process is that it's subject to random audits, and also the processing time varies significantly. So we'll often get asked, "Oh, how long is that going to take?" And quite frankly, it could be anywhere from once you file the application, if you get very lucky, you might get a certification in 2 months, and if you get unlucky, you might get an audit, and then it might take a year and a half. Something, if you end up going through that process, to just be aware that the experience is very sort of variable in that regard. So the third step is the adjustment status for consular processing. That's really your application in which you're asking for your status to be adjusted from non-immigrant to permanent residents. As I mentioned earlier, it's subject to these backlogs, so it becomes important to monitor your priority dates. And of course, if you're working with an attorney, then the attorney will do that for you. And this really is more about sort of your immigration history. They'll look at that, make sure that there were no violations. They'll look at, has there been any kind of criminal issue in the past? Is there any security issue? Is there a medical invisibility? So it typically, in at least my experience, once you've gone through the first 2 steps or the first step, if a labor certification is not required, this is more administrative, and typically, we don't see anyone issues at this stage. And the other way to do it, like I said earlier, is consular processing, and that's just through the consulate rather than in the U.S. with U.S. Citizenship and Immigration Services. The requirements are the same, the process is a little different. We generally prefer adjustment status, but that's not always possible. And this is just as good. It basically we're kind of stuck outside the U.S. for a while. Okay, so that was sort of overview of the non-immigrant and immigrant visa categories. And as I mentioned, I was also asked to touch a little bit upon sort of the recent changes. So we're going to discuss a few of the executive orders that have come out. So one that could impact people in the room is the Buy American and Hire American executive order that was signed on April 18, 2017. It doesn't provide that many specifics, like a lot of the other orders don't either. However, it does direct, various government agencies to propose changes to the H-1B visa program and also other employment-based immigration, programs. It also seeks recommendations on sort of how to allocate H-1B cap numbers better. Right now, it's just this random lottery. But I guess the idea is that we should prioritize advanced degree holders and high wage earners. It also seeks to increase wage minimums. Every H-1B petition has to be filed with what's called a labor petition application, in which the employer will certify that it will pay at least the required wage, which is either the prevailing wage or the actual wage paid to other workers in that position, whichever is higher. So so a lot of, I guess, politicians and various other people the stakeholders have said that really there should be like higher wages for H-1B visa holders. So this could, this could potentially impact, anyone who's here on an H-1B. However, in our view, a lot of these changes that are contemplated actually have been done through regulation or legislation. And legislation takes forever, as we've seen, and regulations also take, typically several months at least. But apparently, this administration thinks that some of these changes can be effected through kind of like policy guidance, so they'll issue like a memorandum or something like that. We haven't seen that yet, but it could happen. So, and then this, of course, I'm sure everyone has heard of this one, the Protecting the Nation from Foreign Terrorist Entry into the United States Executive Order, or the so-called travel ban executive order. This is the second one, so it replaced the one that was issued on January 27, 2017. I'm sure everyone followed sort of the crazy, nets that happened after that, and a lot of lawsuits, of course, and just a lot of chaos surrounding how that could be enforced. So then eventually the first one was withdrawn, and now then they issued this new one. And that one calls for this 90-day entry ban on nationals of 6 countries, so Iran, Libya, Somalia, Sudan, Syria, and Yemen. However, this one has exemptions for a lot of different categories, which is a result in part of sort of the chaos that happened after the first ban, because it wasn't clear in the beginning, like, it didn't apply to permanent residents, it didn't apply to, those that are already here. I mean, it was not very clear. So they made that clear in the second executive order. And also, there's a waiver available for certain, individuals. But the other part of it is under 120 days suspension of all refugees. But as I'm sure most of you know, this particular entry ban or travel ban is not in effect right now. It's been suspended. There was a preliminary injunction nationwide, actually 2 courts. One located in the Ninth Circuit and one in the Fourth Circuit, and so as of now, it's still not in effect. It's suspended. And actually, there were oral arguments on Monday in the Ninth Circuit case, and we anticipate that some kind of decision will be issued probably sometime later this month. So that could change things, of course. Now, even though we are, of course, telling any individual who is subject under this executive order that they can proceed to travel because it's not in effect right now, there should be it should be also kept in mind that this individual may be subject to sort of additional screening because of this other memorandum that I have up on the screen here. Which was issued also on March 6, 2017, which directs government agencies to implement, stringent vetting of applicants and petitions for immigration benefits. So it's possible that if somebody who might sort of fall under this executive order, travel ban, who then goes to apply for a visa at a U.S. consulate, could be potentially subject to this extreme vetting, whereby processing times might, be very lengthy. I mean, we haven't really necessarily noticed that in practice yet, but it's something that we're keeping a very careful eye out for. And then finally, there's an executive order that was issued in February, which was called Enforcing the Regulatory Reform Agenda, which really just ordered a sort of a full-scale review of the regulatory process at federal agencies. That is in effect right now. It's not specific to immigration, but it is expected to eventually lead to changes in regulations, including immigration regulations. So that's sort of, what I can tell you right now about these changes. We actually, my firm has a website called Fragomen.com, in which we have updates on this. So for anyone who's interested, check it out. Certainly, anything that comes up, like the travel ban, or we always issue sort of, notices on that. So if you're interested, feel free to check that out. And I think that was it.
So, thanks so much, Aviva. I think we're running quite late, so probably we're going to ask the panelists to come to the table, and Aviva is going to join the panel, and we will let the questions for the Q&A for later during the panel session. Okay, so I'm Dr. Paradis, going to moderate the panel. He's from the Postdoctoral Society and an associate research scientist here at Columbia, who work to bring this event together, and he actually conceived this idea and has a green card himself.
So thank you very much for the presentation, and I'd also like to ask our panelists to move over to this table in any order. So thank you guys for coming. We're really happy to see such a great turnout. Initially, we wanted to rent Madison Square Garden, but unfortunately, it was not available today, so we had to go at 401. But I think this will do. So I would also like to thank the panel for coming and being available for us and our questions today. So we have Sophie here, who has an H-1B visa on academic. What was that? So is it? Okay. So if you make it available, then we can send it out to the attendees. Thanks for the question. So okay, so we also have Iran, who did an EB1A. I guess EB1A, right?
Yes.
Yeah, okay. And then we have Urinas, who did an EB1B, and we have an EB2, Shamara, who did it without the wire. And then we have an EB2, who did it with the wire and some. And also we have a marriage green card, Alicia. And we have the lottery with Jose. Yeah, that was a sarcastic. All right, so we encourage you guys to ask questions, but please ask questions that are of general interest and not related to your specific case, as our goal here is to give information to everybody instead of giving legal information, legal advice to individuals. And but we also encourage you to ask those more personal questions after the panel discussion at the reception. So approach one of the panelists, or Viva, or approach me, or any of the CUPS members. And then the way you can ask questions here is you can send tweets to the address that Carlos shared with you in the beginning, which is hashtag #ImmigrationInfoCU. Or you can use these yellow post-its that are found scattered across the room, and we have pens available for you. So instead of going around the room with a microphone, we thought it would be much easier to just write down your question and then hand it over to one of our representatives here. And they will bring them to me and I can ask the question. So now to proceed on to the panel, I would like to ask our panelists to introduce themselves, say a couple of sentences about the way you got your green card. So let's start from the left. And you have microphones. And in theory, they should all be working. Let's get it. Okay. Yeah.
Hello, good evening, everybody. My name is Kiran. I'm from India. I'm working as a postdoc at Green Corner, Guidance Department. I applied last year. I applied my green card to EB1A category through lawyer. I'd like to share my experience and answer your questions if you have any.
Hi, my name is Jose. I'm Spanish, and I have been working in Colombia for now 6 years. in the system biology department. In 2013, I applied to the diverse lottery. I was lucky. It was my second time applying. I did it. And then on next year, 2014, it's when I get my green card. Because you have all the process.
Hi, I'm Alicia. I'm from Spain too. I came to the US in 2009 to do my PhD. And during my PhD, I met my husband. He is from the US. So we got married, and I got my green card 2 years ago through marriage. Now I'm a research associate at the Smithsonian Museum of Natural History in DC. Hi, I'm Sophie, so I'm French, and I came to Colombia about 6 years ago for a postdoc. I was on the J1. And 1 year and a half ago, I switched position, and I got an H1B, so I'm now an associate research scientist. And I also have a second H1B to work for a startup. So if you want to know about how to get 2 H1Bs, I can answer your questions.
Hi, I'm Jamal. I'm from Sri Lanka. I applied my green card to February, and I didn't get any help from the lawyer. I did by myself to save some money.
Hi everyone, I'm Marinas. I'm a research associate at Postdoctoral University. I applied for my green card in 2015 to the Assam Professor Researcher category. I didn't go to a lawyer either, but I did get quite a lot of help. I can tell you a little about how I got. Also, I'm a dual citizen. I'm in Iranian, which is possibly one of the worst things you can in the US. So I can also talk about that.
Hi, I'm Wissam. I'm French Algerian, and I'm a senior scientist at Mount Sinai. I applied for my EB2 national interest paper for my residency 2 years ago, and I got it.
Okay, well, thank you. Keep the mic. So let's start with a really simple question. So why did you guys decide to apply for a green card?
Well, I'll just start now. As simple as that, I knew during my PhD I was not going to pursue traditional academic career. It was like ETI, where it's a little easier to visa, so I wanted to get at some point merge into the biotech field. And for that, I needed to have that freedom of employment where I can work wherever I wanted, and this is why I applied for residency.
I applied for green card because I was really fed up with the visa application processes in the US. In Iranian, it was never easy. I always got some eventual visa, and I just didn't want to.
At least I'm the same situation. So I try to do it myself. For sure.
Would you speak up a bit? It's very hard.
What?
It's very hard to understand all of you, actually.
Yeah. I was fed up with the visa application and process, so that's why
I didn't apply. I almost thought I would move back to Europe, but I've been here 6 years, so actually it's interesting for me as well, this panel, because I may apply soon.
I guess that in my case, I have to say, since my husband is in the room, that I applied and that's partially true, but I also, being a scientist and coming from Spain, I had better career perspective staying here in the US.
Well, more or less the same reason that you have said. Definitely, the visa process is much simpler when you have a green card. You don't have to worry. And then the other main reason is that it's not, if you want to get out of academia to go to companies and look for professional opportunities in industry, it's much easier if you have a green card and you have a visa.
I think it's the same reason everybody's saying that, but it's a process. And I'm from India. Whenever I go back to India, I have to attend a visa interview. And I'm the lucky guy. I don't know, every time I get a 221G. That means I have to wait like 2 months to get my visa process going on. So that is really big headache. And the other reason is when I apply for jobs, the first thing they will see is a green card. So it's like one of the mandatory for applying the jobs. So to work on that, so that is what I'm looking at.
So how long did this application procedure take for you guys? The green card application? Like from the very first day?
For applying or?
Yeah, for the entire procedure. Oops, sorry.
I spent like more than 3 months, around 3 months for doing all paperwork, collecting the recommendation letters and all this stuff. And
yeah, but how long did it take to actually get the document? Like the entire process, including
1.5 years. 1.5 years to get the card in hand, right?
Oh, okay.
Yeah, because I applied. Too loud.
No, it's not.
Okay, so I applied I-140 first. After 6 months, I applied for 485. So for the whole process, it took like 1.5 years.
Well, in my case, was like I get it for the diversity lottery, so I applied for the diversity lottery on November 2012. On May 2013, I get the I found out I have the lottery. So I have, in that case, you have to wait to the next fiscal year to make the application. And as she explained before, you have to wait that your number appear in the bulletin, and then is when you can start the process. So I have to wait till around, I would say, February, March of 2013. That's when I submit all the documentation. And then after all the process, I get it. There was some problem with my application, so I get it by the end of September. So basically, all the application took like half a year.
So I applied first to the waiver for the 2 years rule because I was at day 1, and I think that took me like 2 months to get the waiver. And then we started the green card process, and it was like pretty fast. It was like around 4 to 5 months, I think, until I get the letter saying that I had an interview. And because life happened, and we had to reschedule the interview like 7 times, I think. So because of a lot of different reasons. And at the end, for me, it was like a year and 2 months, or a year and 3 months. But without that 7 times, probably my green card would have been like a 7 months process. So I think that in my case, it was kind of pretty fast.
In my case, for the first I applied for the I-140, it took almost 1 year to get approved, and then when the adjustment 485 that's completely 3 months.
Okay, so for me, it was actually very quick. One of the reasons I decided to apply to the D1B was that I could do premium processing. $8,000 extra, but then you get your answer within 14 days. So I knew after a week that I had been awarded the green card, and then it took 3 months until I actually had the card in my hand. Sorry, I just wanted to mention, because it seems like, everyone's process has been pretty quick, which is great. No, but I just want to mention, just to make sure that people don't have sort of expectations in one direction. Right now, actually, processing times are very lengthy in general. So, for example, for marriage-based applications, right now in New York, if you live in New York, your interview will be in New York. It takes about 9 months just to get the interview. And also, just the status application processing times are actually more like 12 months these days. So, that's variable. It could go down, and hopefully it won't go up. But I just wanted to mention that because it seems like everyone's been pretty lucky on this panel, but that's not standard right now.
So for me, actually, since the beginning of my PhD, I really wanted to stay in the United States, so I applied 3 times to the lottery. I didn't get it. Then the last year of my PhD, I applied for B2 national interest waiver and I get it in a year. But I don't know if it's a coincidence or not for both steps. Actually, what happened is that I give a call to Kristen Gilbrand, the senator of New York, and because I learned just researching that can help. They also can help for federal inquiries. And I don't know if it's a coincidence or not. Every time I called, a week later, I had an answer. I don't know if it's that, but at least I did that.
Okay, so received a lot of questions regarding the requirements, the scientific requirements for each category. So how do you read the standards? How many papers or citations did you have when you applied for an EB2 or an EB1? And maybe you can address that there. Like, what are the usual standards?
I can start with is that my application was definitely not usual because I applied, I did not have my PhD yet. I had 2 publications where I was not first author, and that was it. I was fortunate enough to have done my master's and PhD in very known labs and have had PIs that are very well known. And I think that also helped, but at least for my case, I did not have 5 publications, first author, etc. So that's also.
So for me, I think from what I could gather, there are some guidelines for how many papers you need to have or how many citations you need to have. But at the time when I applied, I had about around 250 citations, I think. And I think what was really important and what was stressed to me was that you have to really show that your work is recognized. That was key, more than the number of publications or the number of citations. Okay. So I think that's exactly right. It's not that there's, I mean, it's a totality of circumstances kind of question. And so it's really hard to say, like, oh, if you have this amount of citations, then you're in very good shape, and if not, then it's a problem. And because you can, well, especially with EB11 or EB1A, there's these 3 criteria. There's out of the 10, you can meet 3 criteria. And I mean, typically when we file EB1A applications, we try to meet more than 3. And you know, some might be stronger than others, and it's really like a sort of an assessment that has to be made for each individual case. You know, how does it look? Do you need more? Do you not? Are you fine? I mean, it's such an individual kind of situation with facts that are very specific to each individual case. But the other thing I want to mention about some of these applications, especially EB1A. So not only do you have that standard where you have to meet at least 3 out of 10 criteria, but there's also kind of like a second test that they do, which is called like the final merits test, where they really just look at, on balance, does it appear that this person is an aerodynamic extraordinary ability? Of course, that's very subjective, right? So I think it's.
Sorry to interrupt, but this is the Kazarian case, right?
Yeah.
It's an interesting story. Read it online.
Yeah, I mean, it's based on a case that came out a long time ago, but and there's been sort of many iterations of it in terms of like the way USCIS sort of adjudicates these cases and evaluates them. But yeah, I mean, there's this final merits test that they do. So of course, the stronger your application, the more evidence, the better.
In my case, I have 4 publications. And around 20 citations.
So for H1B, there's no requirement. They ask for your CV, but there's minimum requirements.
Yeah, in my case, I don't think that applies at all. But I have to say that it helped a lot. I was doing a PhD. The research was conducted in Harvard, and I have to say that helped a lot to have smiley faces, and to not to ask a lot of uncomfortable questions.
Yeah, it's the same thing with the diversity lottery. You don't need to fill out your application with any citations or anything. The only requirement is to show that you have a university degree.
When I applied, I have 5 publications and 1 postdoctoral. These are not really big publications, they are small, and I have around 29 citations. But still, that number is not huge. But again, that is not the main criteria you need to meet. There are certain other things you can focus on those. So if you have less citations or not really good publications, you can compensate that with other things. So as she said that there are 3 criteria which you need to meet out of 10. So focus on remaining 7 or remaining 9. You are failing in one case. So if you are really good in other 7 or 6, then there you go. You don't worry about the citations or publications.
Yeah, so does teaching experience matter? Is it relevant?
In my case, I don't have any teaching experience, so I didn't put anything. So I'm not sure.
If I can just add something for my experience with the whole process, and correct me if I'm wrong, but what I tried to rationalize the entire process, and just to, and when I talked with my lawyer, and he just told me that the person that's going to read your application is not a scientist. He's not going to care about the P1000 whatever that you're using, which protein you're working on. So there's a couple of things you need to understand. It's about, yes, if you have a lot of publication, that's great for you, your chances, but it's also the way that you're going to be put to light, how the lawyer is going to write the letter of recommendation, and also the officer that's going to read that application. If the officer is a tough officer and he's going to maybe ask something more, if your application goes on to somebody who's a little bit lighter, it's going to be easier, but it's not everything. Your background is not everything. It's how you put yourself on paper and the person who's going to read that application.
And also, if you're given the chance to review papers, do it, because in many categories it matters. So it's the number of papers reviewed. Okay, so a couple of questions about the 01. So is the 01 dual intent?
That's a really interesting question because it's kind of odd. It's sort of in the middle, which I know sounds weird, but basically it's not officially dual intent visa category. And there is a travel restriction. So for example, if you are on 01 and you want to try the green card version of the 01, right, which is the B11, B1A, and you file, say you currently file an immigrant petition and the adjustment of status application, which you can do in some cases if your priority date, if your priority is current, then we would not recommend you traveling, and that's only because essentially you may abandon your adjustment of status application if you leave the US while it's pending. However, even if you have an immigrant petition that's already been approved, you can still apply for a new 01. So versus if, for example, you have an immigrant petition that's been approved on your behalf, and you want to apply for an F1 or a J1, that would be a big problem because they're going to see that you have immigrant intent. You have immigrant intent. So it's kind of in the middle in a way. And in general, it's better to be on 01 if you are intending to pursue permanent residence than on like a visa category that's definitely not dual intent like J1 or F1.
Right, and can the 01 be self-petition or self-sponsored?
Unfortunately, there's no self-petition option for 01, so that does make it different from an EB11, even though the criteria are the same. So you do need an employer, but what some people, that doesn't mean it has to be like a very large employer or anything like that. And it's any employer that can just kind of serve as a petitioner could potentially sponsor you for 01. Even you have, in some cases, you have agents that sort of act as petitioners for purposes of 01 sponsorship. It depends on the field. I think in sciences it's probably not as common, but in certain other fields like, acting and things like that, you can have an agent who's basically acting as a petitioner for purposes of 01.
Okay. So for a lot of these categories, you will need recommendation letters. So how many did you guys have? And how did you write them? Who decided how many to write?
I think it's we have to choose the people, and I submitted 7 letters from 7 different people. Not from your employer or not from your boss. Those are not important letters. So you need to get some independent researchers somewhere like you, where you made the conference, or somebody who cited your paper, somebody is doing similar experiment, similar techniques, something like that. Or it's better to have some recommendation letters from the industry as well, because they also have impact. When they are reading the recommendation letters, they see where you are getting the letters. Maybe if you get letters from industry, maybe that will be helpful. I'm not sure, but I got a couple of letters from industry as well.
And did they actually write these letters? Or did you have to draft it?
Absolutely. Yes, they wrote it, but they did some content, but mostly I wrote the letters. Well, I'm not supposed to say that, but yeah, I wrote those letters, all the letters, and make sure when you guys are in a like situation like me, you have to write your own letters, make the difference from one letter to other letter. So if I write 7 letters, I do the same grammatical mistakes. So don't do that. So take your friend's help or contact somebody, your seniors who already got it, who are in the process, and get the templates and work on it.
Well, in the case of the diversity body, you don't need any letter.
So in the marriage case, you don't need recommendation letters, but you need affidavits that basically saying that your relationship is real. And I think that we submitted around like 12 letters, and we decided to like his family, my family, and also people related with my PhD, like one of my advisors and another PhD student in my lab. So we selected people like basically from all the sectors of our life and our families.
Why should we don't need letters?
In my case, I submitted 6 recommendation letters, all by myself. And make sure it's different. And another thing I did for my papers, usually we get the comments from the reviewers. And then I took those as a kind of recommendation. And then I wrote, it's not the letters, but in the petition I mentioned those kind of things. Interesting of my work.
So I gave 7 letters. I've heard anything between 5 to 10. And I wrote them myself as well. And I have one more that was actually from my current boss, so that's possible. And I just tried to kind of remember anybody that sort of had any kind of interaction with, and I reached out to them, and everybody was happy to provide what they wanted to know. Basically, a lot of people know about this process and are willing to help. Yeah, so and the other thing that really helped was that I got a lot of letters from friends who've gone through this before, just to get an idea of what you were supposed to write and what they were supposed to reflect, very sort of specific format that they should come in. And so then it was much easier to strike these letters based on what that would be like.
For my case, I didn't write them because I'm actually going through the process wanting not to write them because I'm not good at writing. And this is like why I chose my lawyer specifically because he also had a PhD in biochemistry. So this is why I was very confident to understand what I'm doing, to write the letters, and especially for EB2 national interest waiver, it's very important. So and which is only $500 more and a lot less headaches. Mentioned. So this is why I went through that, and I got my boss, the chairman of my department, and 4 other people that I collaborated with or studied with.
So the recommenders, they don't have to be U.S. citizens, right? No. So they could be basically anyone.
Well, it's actually good if you have other people from outside.
That's what I thought. And also, do they have to be like really big shots in their field, or does it work if you just
But aim for the big shots, but not necessarily the big shots, but aim for the big shots. Yeah. Those has an impact. Yeah.
Right. So a lot of people seem to be interested how it is possible to transition from a J1 to either an H1B or a green card. Are there any limitations? Because the J1 is not an immigrant visa. So in theory, you're not supposed to apply for adjustment of status. But still a lot of people do it. So what are the limitations?
So it's true that if you're on J1, you certified at some point that you had intention to go back home, right? And that you were gonna sort of use or bring the skills that you sort of acquired while you were in the US, and you were gonna sort of give that benefit to others back home. And now you're kind of saying, well, but I don't really want to do that, right? Or at least I prefer to stay here. So that is an issue with intent, which is why, you know, typically, for example, you would want to file a different application sort of right after you enter on a J1. Thankfully, we've not seen it come up much in terms of like if you do eventually adjust status from a J1 status to H1B, which also indicates you're not going to go back home right away. Thankfully, we've not seen that challenged. You know, is that something that could ever happen? And sure, but so far, I mean, you know, changing status from a J1, for example, to an H1B, which I mean, for example, one of my clients is a nonprofit research organization that is able to sponsor H1B because they're CAP exempt. And they hire a lot of J1s, and so we do change the status from J1 to H1B, and we've not seen any issues with like intent or anything like that.
Right. And so those of you who had to do the waiver, how long did it take to get it? Or actually, if you don't, maybe later you can address that. How long?
It was actually a 2-month thing. It was not that difficult. I sent an email to the Embassy of Spain, and they gave me directions on how to do it. They put me in contact with the person in the Secretary of Education, I believe, and so I had to ask for a letter for at that moment, Ministry of Science in Spain, which doesn't exist anymore, and basically saying, because I was in the US with a fellowship from them, so I needed a letter from them saying, yes, we don't care if you stay in the US. And so I with this letter, I also needed a letter explaining why I wanted to stay in the US, and basically was a short letter saying I got married with an American, so I want to stay here, and I sent everything through the Spanish embassy, and I think that after submitting everything, probably a month, and I got a letter saying that I was approved to change my status. So it was not, the most complicated part was the Spanish government, to get the letter from them saying that they didn't care if I stay in the US, because they kept saying this, but in an email, not in a letter. So that was the most complicated part. Other than that,
once again, just set expectations. So, I mean, it's great. Your process was super quick. I do want to mention it depends very much also on sort of what's the basis for which you were subject to foreign residence requirement. And it sounds like in your case it was like government funding, but from Spain. It's very different if it's government funding from the US. For example, if you are a Fulbright scholar, it's very difficult to get a waiver. It's essentially impossible to get a waiver. I mean, every now and then we'll hear somebody who did get it, but in general, the Department of State has a policy against waivers for those that have Fulbright funding. So you know, individual cases differ significantly in terms of like how simple it is and how difficult it is, and also the process. For example, one time I had to look up the process for getting a J1 waiver for somebody who also was Spanish. The Spanish embassy has a very clear process for applying this no objection statement. You just follow steps 1 through whatever it is, and that's it. Very clear. Other countries have a very unclear process. You know, you have to follow up a million times. You don't exactly know what to do. So, and also it takes much longer. So, depending on where you're from, it could vary from maybe 2 months to like, you know, more than a year or more. So, highly variable.
So then also, a lot of people are worried what would happen if their visa status were to expire during the application procedure. Is it an issue?
That actually happened to me, and no, it was not an issue. I was, so we filed everything, and I mean, so in my case, since I was married to an American, they were not going to get me out of the country. So, but I had to go to Spain to defend my PhD, and I didn't have a green card, and I was in a non-status moment. So at the same time that I was filing my green card, I also filed for a parole. So they gave me pretty quick like a green card, but it's not a green card, it's a parole. And with that, I was able to travel. And that's, I believe, and correct me if I'm wrong, that was also like the working permit. And there was both things, to travel and to be able to work. And I got that pretty quick. It was like, after submitting all the paperwork, probably it took that like 3-4 months to get that.
Yes, so that's actually a really good point and a good tip for everyone in the room who's applying for adjustment status. So with the adjustment status application, you can file applications for employment and travel authorization. And some people don't realize that, I guess, but it's, I mean, it makes a huge difference because generally within 3 months or so, 3 or 4 months, which is your employment and travel authorization card. And, you know, depending on what status you're in, I mean, as I mentioned earlier, if you're adjusting status for J1, you can't travel without that. If you travel without that, first of all, you abandon your adjustment status application, and secondly, you are not going to come back in. So, yeah, so I highly recommend anyone who is applying for adjustment status to also file these applications for employment and travel authorization, and there's no extra fee. So, I mean, you know, there's no reason not to do it, basically.
Sorry, I'm so sorry to interrupt.
Sure, go ahead.
Actually, so this is a really important thing. I just spoke to a lawyer recently, and I was under the impression that if you're non-immigrant visa, finish it, and you're in this pending status, as long as you have an EAD, you're okay. But she just told me that 6 weeks ago, she was at a conference, and there's all these new rules that they're having, that you have to maintain non-immigrant status, non-immigrant visa for the entire process until your green card is in your hand. So that even with that EAD, you're subject to deportation. So if you're running a risk of your J1 finishing before, like while you're in pending status for a green card, that you're subject to deportation still.
I mean, so basically, if you have a valid eventual travel documents, then that is sort of advanced approval from the government that you can travel. So, but that doesn't take away the fact that, you know, if your underlying sort of non-immigrant visa status has run out, you're still technically, sure, you're subject to rules of deportation. I mean, you know, you don't have underlying valid status, but I would say in most cases, this doesn't sort of come, you know, this is not an issue. So
you said it might become an issue with the new.
Okay, I mean, it's good. I mean, you know, like we're in this sort of period where things change very quickly. And it's certainly very important, I think, for anyone who's applying for anything to kind of be mindful of, you know, it's not an easy time, right, to be an immigrant and to file these applications. And I mean, you know, things change very, very quickly right now. So, but up until now, I mean, it's always been fine to, as long as you have the valid employment and travel authorization documents, to travel once you, even if you're not underlying whether your visa status has expired.
So it actually happened to me when I filed, because just before filing my second part, the adjustment of status, I actually lost my J1 visa. So I was in this limbo between, I didn't have the work authorization, but I could not leave the United States because I was not authorized to come back if I would be abandoning my position. So what my lawyer told me and what happened is just file as soon as possible, and legally they have to give you an answer for your work permit and your travel authorization 90 days after you receive your application. So worst case scenario, 90 days after you apply, you should get your work permit and your travel authorization. This is what happened. I lost my J1 visa. I took me a month to get all the paperwork together, file for adjustment of status, and then after that, I waited 3 months and I got my advance parole, and then after that, I managed to travel.
So then if you're applying in an employment-based category, even for H-1B and also green card, different green cards, can you switch jobs during the application procedure, or is it not recommended?
So generally, no. In part because for most of these categories, they're sponsored by an employer. So, and unfortunately for some people, especially those that are subject to lengthy backlogs, it means that they may be sort of stuck with their sponsor for many years, which of course has its own problems. But even if you if you self-petition, then that's probably the only exception where it doesn't matter. But in every other sort of category where you're sponsored by an employer, if you leave, then you kind of almost give up that application. You'll have to be sponsored by another employer.
So in the family-based green card, what qualifies you as a qualifying family member to sponsor green cards for others?
I think that basically what they asked my husband was his salary. And that was basically it. If he was,
That's pretty straightforward.
yeah, if he was able to support me. And
I think the question was more about the.
Yeah, but that's a good answer. I think that's really helpful. But the question did actually want to reflect more on the family-based green card application, which is sponsored by a family member who's a U.S. citizen. So who qualifies?
Okay, so essentially there's several sort of categories. So there's immediate relatives, and that's basically if you're the spouse of a U.S. citizen, or the parent of a U.S. citizen, or the child, or the immediate relative. So you can be sponsored by that family member. Then there's also preference categories, kind of like we discussed, EB1, EB2, EB3. It's the same in the family context, and there's a whole system, but it generally is limited to basically like children, so like married or unmarried, and it depends again if the sponsor is a permanent resident or a U.S. citizen. U.S. citizens can sponsor siblings, that's family fourth preference. Family first is unmarried children, like adult children of U.S. citizens. Family second is children and spouses and unmarried adult children of permanent residents. And family third preference is unmarried, is married children of citizens. So there's basically a preference system, and you have to fit within these very specific categories or else you just don't qualify.
So can one apply in multiple categories at once, such as multiple H-1B categories at the same time, or multiple green card categories, or even an H-1B and a green card at the same time?
Yeah, if you're eligible for multiple types of applications, you can make multiple applications, but it depends on exactly what. For example, I'll just give you an example where it came up recently. I'm applying to visit married to a U.S. citizen, so her spouse, I assisted with a marriage-based green card application, but this person is actually also a professor at NYU, who also started a green card application for him on an employment basis. So he actually had sort of two petitions, one family-based petition and one employment-based petition. But I basically advised, because we had already filed an adjustment of status application with a marriage-based application, so I said, I don't want you to do another adjustment status application because that doesn't make sense. Like his marriage-based adjustment status application is going to be adjudicated. It's just a matter of time. So yes, you can apply under multiple categories, but the exact sort of process differs. And once again, you shouldn't have two adjustment status applications pending.
Very good one from the audience. So, do tickets such as speeding tickets or parking tickets matter for the background check that we all have to go through when we apply for adjustment of status? Or are they only looking at bigger threats?
So, thankfully, traffic violations are sort of excused. So, I mean, you don't want to have like a pattern of tons of traffic violations, but because this is another good point, adjustment of status is discretionary. Okay, so even though you might have an immigrant petition approved under whichever category, still the government kind of gets to decide ultimately. They have discretion whether or not to grant this benefit of becoming permanent residents. So if you show the history of sort of flouting the laws, then that could be an issue, But in general, I mean, traffic violations are not a big issue. But DUI, for example, I don't know if anyone, I'd be curious to hear if any of the panelists had any kind of issue like that, but DUI comes up much more than you think, and it's not an automatic sort of bar of disability, but maybe they've been focused more on it, so even though technically it's not a crime involving moral turpitude, which is like sort of a main thing in the criminal context for these applications. But they might, based on discretion, decide not to approve an adjustment status application if there's like multiple DUIs. So I guess that's kind of like a warning.
Okay, so then the big one, how much did it cost? So if any of you is not comfortable answering, that's fine, but a lot of people are curious.
What do you mean, how much?
So the entire procedure, like how much did you spend on this?
I think it depends on the lawyer.
Yeah,
it depends on the lawyer. Some are very expensive.
What's your personal experience? So again, if you don't want to answer, that's fine.
But me and my wife, I spent like $30,000, which includes everything, fees, everything. 13,000. 13, 1 3. But me and my wife. So
that's again in which category?
EB1A.
And did you go for the expedited?
No, which is regular cost, not paying premiums like 1250, 450,000. Yeah. It's like a little bit expensive, but it has good reviews. I'm not advertising him, so I don't want to give his name.
Well, in the case of the residency lottery, it's much cheaper than the usual process, basically because you don't really need a lawyer. It's, you can do it by yourself. I did it by myself. So I would say with everything together, usually at least 3 years ago was, I would say, like 15. Then that would say if everything goes well. Well, if something happened, then it can be really more. In my case, I have a little problem. Was basically all the process go through. All the notification that they send you go through mail. And one of the notification to go to the interview. So I didn't know I have an appointment. I didn't appear, and because I was not there, they sent me another notification telling me that they were going to drop my application because I was not interested in it, because I wasn't there. So I have to appeal. To submit an appeal process, it came with a tax fee of $600 to appeal. So in total, I spent like $2,000, but that's an initial case, I would say.
I would like to add one point here because when you guys are choosing a lawyer, don't think about the money, cost, how much he's charging. See if you have any friends who applied to that lawyer and get approved or not. Because some lawyers, they are expensive, some lawyers are okay. So we don't want to spend that much money because we are not that rich yet. So we go for who are charging less, but that's not easy. If you are going for a lawyer who is charging less, that means maybe you have to do more work. Maybe you have to pay more attention to that, why he's doing that and what what's the process and all these things. The easiest way to pick the lawyer is talk to the lawyer and see if he has any kind of checklist. For example, in my case, I went to review 1A category, so my lawyer gave a like, you have to meet this, and see whether you can meet. If not, what you can do. So talk to the people who are applied to the lawyer, whether the lawyer is helpful in that scenario or not. If he is helpful, he charge you more, just go for it, it's worth. But some law, yes.
Yeah, I just have a quick remark that some lawyers offer refund patients from other people.
I don't think lawyers would refund. That is only one way to go.
Yes,
I don't think you are
my lawyer had that when I signed the contract with him. He told me that in my case, if the application was denied, he would refund me half of the fees. And for me, it was EB2 national interest waiver, and it cost me $7,000 all in all, and I didn't do anything. He did everything. He wrote the letters, and I chose that lawyer because 5 people of my department chose him, and they got it, and yeah,
So in my case, it was everything was $1,800, which is like not a lot of money because we used a pro bono lawyer. We were based in Boston at that moment, and we went to the Irish International Immigration Center, and they have immigration lawyers that work for only $300. I know that you guys are in New York, but if someone is watching us through the streaming and is in Boston, that's totally a possibility. They are real lawyers, and and you don't have to do anything. So we had a real lawyer doing all the work for us, and she was amazing, and it was only $300. So we had to pay for the taxes and for the papers, and I believe that was $1,500. So the whole process was $1,800 at the end.
But the H1B is usually paid by your employer, and it costs about $300. And if you want to do the premium processing, it was an extra $1,200, I think.
In my case, I did by myself, as I save a lot of money, and then only the visa fee.
Yeah, so I did it myself too, and I think it came to around 2,800. And that I think also included premium processing fees to $8,000. So if you can wait and you don't have to do premium processing, it can be even cheaper. But yeah, the way I was able to do it by myself was that I actually got a folder of a friend of mine who done it. And so then it was very easy to kind of look through everything and just figure out what was needed and just get it all together. So it's a little bit more work, but you can do it on the cheaper.
All right, so that was a nice segue, highlighting how important networking is. My suggestion is to continue this discussion outside with some food and beers in our hand. So I would like to thank the panelists and the legal once again. And I'm also sure that we were able to answer every question, but then again, we can continue outside. Thank you very much.
Le doy esto. Sí,
Stay for a couple more minutes.